Good morning to all of you. Welcome to Torts class. Friends, we have been discussing the topic of defamation and now we have come to the useful part for the advocates, that is defenses for defamation. Normally, whenever a person files a case of defamation, so if the client comes, you must be able to defend him. Defense is most important. That's why defenses, please learn them without any hesitation. So for the defamation, already I told you in section 499 of the Indian Penal Code, there are 10 exceptions. Even in the Contempt of Courts Act also, there are 5 exceptions. So normally the accused person, the contemner, they will be given long row to defend themselves, because the so-called dissidence is a decent aspect in democracy, right? So now we are going to discuss the important defenses. Number 1, justification / truth. Normally we call it as justification by truth. Justification / truth. Second, so then purpose is the public good is required. The public good requires the matter to be published. That is how they will justify. Then second is fair comment. Fair comment, please remember, it can be called in 4 ways. A rolled up plea, honest opinion, or the so-called bona fide comment. So anyway, this is called as fair comment. Here you have to remember, you can make comment on the judgment but not on the judge. Third one is privilege. This privilege is of 2 types. One is absolute privilege and qualified privilege. Absolute privilege. Suppose if maybe military, navy, all these things are concerned, definitely you cannot publish anything. It is totally privileged. President of India, he has got the privilege or immunity. You cannot file a case against him. And second is qualified privileges. So already, for example, lawyer. So the privilege to the lawyer is, even though the accused, the client comes to you and says that he committed the murder, you need not inform the police. So this is a privilege, is it not? Likewise, consent. So when you yourself give consent and you cannot once again file a case of tort. It happens. Some people say, నా మీద నువ్వు అనవసరంగా రాశావు, క్షమాపణ చెప్పు, లేదా పొరపాటు అని చెప్పి వదిలేస్తామని చెప్పి, వాడు పొరపాటు అని చెప్పిన తర్వాత వాడి మీద కేసు పెడితే ఎలా ఉంటుంది? This is what's called consent. Then apology. Apology is the most important one. Very recently I told you, in the case of Rohini Sindhuri versus Rupa Mudgal, Rohini Sindhuri sent a notice to Madam Rupa Mudgal stating that please tender an unconditional apology, otherwise pay 1 crore as compensation. Apology is the best method. Even in the Contempt of the Courts Act also, apology according to section 12, we say apology is the best method, because who will be getting the so-called defamation? Only educated people, only highly, normally like lawyers, higher cadre people only. So for that, for them, అందుకే మనిషికి ఒక మాట, మంచి గుడ్డుకో దెబ్బ అంటాం కదా, అదనమాట apology. Then sometimes the publication of proceedings of the court, so they cannot be taken as a defense, even though unreported. Some cases will not be reported. In such cases, if you publish the judgment as it is, yes, definitely it will be a good so-called defense. So these are the 5 defenses, please remember. And good faith, don't forget, good faith or fair comment, all these things, they come in the same line, but sometimes good faith will be taken as a separate defense also, right? Now we are going to discuss the defenses one by one. First of all, I want to tell you the so-called justification by truth. Justification by truth. So, or justification / truth. Simi Grewal versus TN Ramachandran, 1974. Simi Grewal was yesteryear's very famous actress, and she acted in a film called Siddhartha, which was released in America, not in India. And of course, in that film she acted nudely, and photos were published in magazines of America, and TN Ramachandran published the same in India, and with the caption saying that, will India be denied the original version of Siddhartha? Can't we see the original version of Siddhartha? and she filed a case of defamation. But court held no defamation. Why? Already the photos were printed in America, they were seen by so many public, and this man showed only the copies of the same. No defamation. So yes, the justification or the truth has been accepted in this particular case. Second case, Salena Dandasi versus Gajala Mallareddy. Yes, 2009. You may be knowing Salena Dandasi is an advocate from Srikakulam district, and this Gajala Mallareddy was the editor of very famous weekly newspaper by name Andhra Bhumi. So a news item was published in Andhra Bhumi that this Salena Dandasi, who was an advocate, he was involved in a case of rape of a Harijan woman. So this is the story. Now normally, is he fit to act as an advocate? హరిజనుల మీద దౌర్జన్యం చేసేటువంటి వాళ్ళు అడ్వకేట్గా పనికి వస్తాడా? ఈ ప్రొఫెషన్ ఎంత మంచి ప్రొఫెషన్, దీంట్లో ఇలా వస్తే ఎట్లా అని చెప్పి మషాలా. యాక్చువల్గా పేపర్ వాళ్ళకి కావాల్సింది అదే కదా. హీ హాస్ యాడెడ్ థింగ్స్. బట్ కోర్ట్ సెడ్, ప్లీజ్ రిమెంబర్, the news item has got exaggerated versions and several deviations. అసలు అయితే దానికి పక్కకి ట్రాక్ వెళ్ళిపోయారు. And improvements, as though the plaintiff or the advocate is a misfit in the legal profession. AP High Court said that such publication has actually reduced to the true episode, asala kadane, to its lowest bottom. It is deprecated. Plaintiff was awarded 10,000 as compensation. So kabatti, so I have told you the positive and negative examples also. Please read them thoroughly and enrich your legal knowledge. We will discuss another defense in another video. For the present, I am staying back. Thank you.